because we don't have a whole lot of time left on his probation, and I'd like there to be some supervision aspect to whatever's happening.
Yes, sir. Sounds good, Your
Mr.
Honor.
Bell, did you follow all that?
Yes, sir, I surely did.
Do you have any questions?
No, sir, I just waiting on Mr. Patterson so I can speak to him and let him know what type of drug problem I got and would like to be accepted in this program.
Okay. Well, it sounds like you'll talk with the folks from Stand tomorrow.
Tomorrow,
and,
yes, sir.
And then A Better Way Ministries the end of this week. So put on your happy face, let them know what's going on and what you need, and
Right.
they'll ask you the questions that they've got, and then we'll get back together to figure out, does a program make sense? Did you get in the programs? And I'll certainly want to hear from Ms. Sellers to get the state's perspective in light of what's been going on and the fact that we missed you for 2 whole years from drug court. Ms. Sellers, anything else on Mr. Bell's case?
No, Your Honor.
Okay. Well then, excuse me, Ms. Nelson will be in touch, letting folks know when we might be reconnecting with Mr. Bell. I'm not 100% sure what's going on with the different virtual calendars from the different facilities. I just know that the good folks from the sheriff's office are doing everything they can to get folks available, and we'll try to figure out how to get Mr. Bell on one of those lists. All right, thank you.
Thank you so much, Judge.
Oh, so we're
you.
clear, Mr. Bell, I am terminating you from drug court. You only have 1 case left in drug court now, the 17 SC case, but because you were gone for 2 years and because you are, I think, most keenly aware of all of us of your needs, you don't want outpatient. That's not the kind of thing that's going to wrap you up enough to help out. And so drug court's not going to make sense. Drug court is not able right now to get folks into inpatient places. They aren't taking many people at these times. So we'll take care of the termination paperwork, but you are terminated from drug court, and we will talk again soon. Okay. Thank you.
Thank you, Judge.
Thank you, Judge.
Your Honor, may I be excused? That was my last client.
Yes, ma'am. Appreciate it.
Thank you.
All right. Mr. Hamilton is next. Is he up?
Yes, Judge, we're ready.
Okay. Why don't we get Mr. Hamilton up? And then I need to ask Ms. Patel and Ms. Winfrey, when I printed out the motions and looked at this, I thought, well, maybe we already talked about this. And I do not mean for you guys to have to re-argue anything. But Ms. Nelson and I were looking around for cases that we could try to move forward in this setting where we wouldn't need witnesses. And I thought maybe we had already talked about this case, because then I recognized the sort of setting with the 2 alleged victims, and it started coming back to me. So if we've already argued a lot of this, we don't need to re-argue it. We're going to get on the record in a minute. But in the future, if we put a case on the calendar to cover something and you think we've already covered it, reach out to Ms. Nelson to say, I'm confused. What are you guys doing? And the mistake may be ours. It happens all the time. But let's go on the record. You are Mr. Hamilton, is that right? Can you raise your hand?
Yes, Your Honor.
Great, I see you. How you doing, Mr. Hamilton?
I'm doing well.
All right, so this is 19 SC 172-425, State versus Tyrus Hamilton. Mr. Hamilton is charged with trafficking of people, and I'm pretty sure we had a court hearing on this case, and it may have just been a status conference to figure out where we are and what's going next. I have 3 pleadings that I want to talk about. We can go as deep as we need to because they're not evidentiary in the sense that no one needs to take a stand and provide testimony. I'm going to start with Ms. Patel's. She had wanted NCICs on the 2 complaining witnesses, Ms. Duhart, D-U-H-A-R-T, and Ms. Hofmeister, H-O-F-M as in Michael, E-I-S-T-E-R. So first, Ms. Patel, am I remembering correctly that we've actually already talked about most of this?
Yes, Your Honor, we did address the state's motions and my motion.
So let's get an update. How are you doing with those NCICs?
So I believe Your Honor had instructed the state that they only had to provide what they had, and that Ms. Winfrey indicated she only had an NCIC for Ms. Hoffmeister, but not Ms. Duhart. I could be wrong, Ms. Winfrey, if you could remember that.
I believe I remember that, and that was provided in the initial case file with the discovery filed in November, so.
Right.
yes.
Okay, so it remains the case that what the state has, the defense has, the state may be rolling some dice by not running an NCIC on a more current one or one at all for one of these. But their ability to get this kind of information, while it may be a little easier because of access to terminals and whatnot, it is my understanding that maybe not the NCIC. I know you can get a GCIC, Ms. Patel. You are able to get something like that, but I think there was allegations of activities in one or two of the Carolinas, and hence the NCIC as opposed to just a GCIC. So you have nothing new, but in part that's because the state doesn't have anything new to give you.
That's correct.
Okay. All right. Then Ms. Winfrey, you had filed dueling rape shield motions. One that was going to let you pierce the rape shield, and then another that would let you use the rape shield law to exclude certain things. And it was as I reread these motions today in preparation for the calendar that I realized, oops, we probably talked about this. Do you feel like you had an opportunity to argue those motions?
I do, Your Honor, and I believe we spent some extensive time actually arguing these motions before the court. And I remember you indicating that a part of your rulings or ruling on this particular motion will be contextual. So, that would be some facts that you may need to hear in order to really decide what comes in and what stays out. And so that's my last understanding. If Ms. Patel would have concurred, that I believe that's our last understanding on that particular motion.
Yes, we were waiting on your written order, but I believe that some of the issues the state and I and Your Honor recognized might come up if this case were to go to trial. And so not everything could be addressed in the motion fully.
Okay. Then this will be much shorter than I had envisioned, because I have my notes. I just need to go get them. And I did not see in the docket that I had entered an order ruling on these. I'm not going to ask you all to re-argue them. Mr. Hamilton, I hope you are remembering better than I did initially that you did have an opportunity to be in court before the health crisis arose, and that we did have a pretty healthy discussion about the state's motions, and Ms. Patel made argument on your behalf. And really it's on me now to enter an order that provides some guidance both to you and your lawyer as well as the state as to what might happen should this case go to trial. Is
Yes,
that
Your
your
Honor.
recollection?
Yes, Your Honor.
Okay. So then really what we need to do, I'll get an order out. That's not the issue. We need to figure out what's the right next place for this case. Ms. Patel, if it's going to be a jury trial, obviously it needs to wait for a while, or anything where we need to get everyone into court. Is that the likely end point for this case as best you can tell right now, or are you and Mr. Hamilton working through other scenarios?
We might work through some other scenarios. We haven't had a final plea yet, and it might be that Ms. Winfrey and I can potentially resolve this short of trial. We just haven't had an opportunity to really talk in person about
Sure.
the charges, to also talk with my client. But
Okay.
Anything's possible.
Okay, well, I need to get that order done then. I will do that. And as we begin to do a slow reopening here, it might be that Mr. Hamilton would be one of the cases that we would try to bring over for a final plea, so that people are in closer proximity than they are right now. But that's something that all the lawyers need to be comfortable with. So we'll work through that in the next few weeks, what some court appearances might look like and cases that would benefit from having people here rather than in this virtual setting. But before any of that would make a lot of sense, I need to get the order out so that people know a little bit more what the trial would look like in terms of what would be excluded or not based on the motions that the state filed. So Mr. Hamilton, I apologize for maybe getting you either excited or annoyed that you were going to have to get in front of this computer and like, wait a minute, you know, my lawyer tells me these motions, I thought we already talked about them. I didn't do a good job of filtering this stuff out. There were a few motions that looked like we could have a discussion without having people in court, and these were some of them. But unfortunately, we already had those discussions. Do you have any questions, Mr. Hamilton, of me? You may have lots of questions for Ms. Patel, but this isn't the time for you two to speak privately. It's not very private right now.
Right. No, Your Honor, I'm appreciative, you know,
Okay.
just for being in front of here, so I'm fine.
All right, well, know that we are trying to move your case forward. I'll get the order issued on the state's motions, and that'll be progress. And then we'll figure out what the right next step. I mean, it's going to be a final plea is the right next step for your case. We'll just need to work out what that looks like logistically.
Judge, he's tentatively scheduled for July 7th or July 2nd, but you know, that's subject to change. But
Okay,
he is on a final plea calendar for that day.
for July 2.
Yes.
Great. Okay. Ms. Winfrey, anything else for the state in this case?
No, Your Honor, nothing further from the state.
Okay, and I'll remind you, I know you know it, but I'll remind you, if for whatever reason your investigative team does rerun or run for the first time any criminal histories for either of the two complainants, make sure you get a copy of that to Ms. Patel. Ms. Patel, anything else on Mr. Hamilton's behalf?
No, Your Honor.
Okay, well, thanks, folks.
Thank
Thank you, Your
you.
Honor. May I be excused?
Thank
Yes,
you.
ma'am.
May I be excused?
Yes, ma'am.
Thank you, Judge.
Thank you.
You bet, Mr. Hamilton. All right, that gets us to Mr. Parrott.
Hey, Judge.
Hey, Mr. Hudson, didn't mean to leave you in the waiting room for so long. I had forgot to check that, but
Yeah, Ms. Nelson has sent me an email letting me know I was in the break room. It's okay.
Okay.
All right.
give me 1 second. So before we start, I'm just going to read, Mr. Hudson, you sent an email as I was scrambling to get out into the courtroom. You copied Ms. Hall, so she got it. I'm just going to read that email to myself before we get on the record with Mr. Parrott, okay?
Yes, Your Honor, I just wanted to add one thing. Ms. Hall and I spoke before I sent the email, so that was a joint email that I sent because she already was about to send it to you, so she had reached out to me.
Okay.
Thank you.
Okay, so Mr. Forte, you ready? He's ready. Let's go on the record with position 4. This is indictment 20 SC 174043. It's State versus Dontravius Parrott. Mr. Parrott, how you doing today? I can sort of hear you. You're going to need to move maybe a little closer to the computer.
I'm doing fine, Your Honor. How are you?
Great. I am doing okay as well. So, Mr. Parrott, Mr. Hudson has been working hard on your behalf and probably taking up more of Ms. Hall's life than Ms. Hall would like, but he has convinced Ms. Hall and persuaded, you can pick your verb, but in being persistent, gotten Ms. Hall to agree to a particular recommendation. If you were going to enter a plea today, I'm happy to repeat that process. I will preview what I'm thinking, and then it may be that you, Mr. Parrott, want to speak real briefly with Mr. Hudson privately, because you're able to do that. I'm able to move you into a little conference room. It's a virtual conference room, but only you and Mr. Hudson are in it. And that way you guys can speak freely and you don't need to worry about me hearing it or Ms. Hall listening in or anything like that. But I did review what the proposal is. I think I'm remembering your case. This is one where someone threw a grill or a barbecue and you fired a gun. I can't remember if it was into an apartment or out of an apartment. And I told you what I thought an appropriate sentence would be after we went through the plea colloquy, and you heard me and said, no, thank you. And you've been back in custody since then. Mr. Hudson has gathered some more information about you, and we'll get it all on the record if we're going to go forward. But I wanted you to know that in light of what he shared and the fact that the state seems to be in agreement with what Mr. Hudson has come up with, that a sentence I'd be comfortable with, and we would work out what the probation side is. I know there'd be a suspended piece, but I think still that what happened was pretty serious. I think 6 months with credit for time served would be the custodial portion that I would impose. Most of the rest of it will look a whole lot like the 2 lawyers, the prosecutor and the defense attorney, Mr. Hudson, have negotiated. But I'm not comfortable going below 6 months unless what I'm going to learn today from Mr. Hudson is actually you didn't have a gun and you didn't shoot the gun. So you may think that's still crazy and not what you're interested in, but I wanted to give you a sense of that. Normally, I don't talk about what I would do with a case, but we already had an entire plea conversation. I learned a lot about you and about the case from both Ms. Hall and from Mr. Hudson. And so I think it's appropriate for me to let you know that I've shifted a little bit, but that I don't see things 100% the way the 2 lawyers do who are involved with this case. And that may be something that you're willing to live with. It may not. But rather than go through the entire important process of the plea conversation, we'd need to repeat it and make a record of it. I thought that I would at least give you a sense of what I was thinking in light of what the lawyers shared with me. Do you have questions about what I said?
No, sir.
Do you want to talk with Mr. Hudson for a minute?
Yes, Judge.
Okay, whether you want to or not, he's going to talk with you. Let me see if I can make this happen. Hold your breath. Oh, and let me say this. When you're done with your conversation, I cannot drop into the conference room to nudge you or something. There's going to be a little button on the screen, and you need to say, I'm all done. You exit the breakout room. That's the only way you can come back to this room. So make sure you exit the breakout room, okay? Let me see if I can make this happen.
Yes, sir. Yes, sir.
I'm gonna press everything.
Are we good to talk now?
Nope, not yet. You'll know, you won't see the rest of us on the screen.
Okay, thank you, Judge.
I'm back. While we are waiting on them,
We
Does
ready,
it-
Judge? You ready for Mr. Hardiman?
I was just gonna ask.
I'm ready. I got you. I'm moving and shaking.
You are
Hold on.
flying. You
I
got wings
am.
on your shoes. Mr. Franklin, should we talk about Mr. Hardiman?
Yes, Judge, we can.
Great, let's do that. Let me get his case up here. Mr. Forte, are you able to bounce from one to the next? Great. All right. So this is position 5. It's indictment 20 SC 174741. Mr. Hardiman, you are charged with armed robbery and carjacking and aggravated assault. And Mr. Franklin has filed a motion for bond on your behalf. So we are going to talk today about whether setting a bond in your case makes sense. And if so, what that bond ought to look like. I have your case in Odyssey in front of me now. Mr. Franklin, I am ready to hear from you.
Thank you very much, Judge. Mr. Hardiman is 20 years old. No adult history. I spoke with Ms. Hall earlier this morning, and I understand he does have some juvenile history that I believe she will go over. I'm making a request for a signature bond through pretrial services, which is a bit unusual for these kind of charges, but once I kind of gloss over the nature of the allegations, I believe you'll understand why I'm requesting a signature bond and not an actual cash bond. So the incident kind of arises from a party that began on January 1st. The complaining witness, I'm not sure if his last name is Nixon or Dixon. He's referred to as both in the police report, so just a typographical error somewhere. Stated initially on the first, he stated that he had gone to a party, he had met a person by the nickname of Menace, who the police later determined to be Mr. Hardiman. He states that he got into his car, dropped something on a sidewalk, realized it, went back to grab that item, and that this Menace person jumped in his car, drove off with it. Those are allegations at that point in time. The cars recovered in Mableton, Georgia. Sometime afterwards, I want to say it's around the 8th or 9th of January of this year. At that point in time, Mr. Nixon/Dixon then comes and speaks to the police again. He tells a different story. He says that the person Menace had showed him a gun at the party, had mentioned robbing someone, and says that when he went to his car, that Mr. Menace, aka allegedly Mr. Hardiman, then puts his hand on his side, presumptively touching the weapon, and tells Mr. Dixon/Nixon to get out of the vehicle, and then takes the vehicle. There were no injuries as a part of either part of the telling of this allegation. I will say that the part of the reason that was given that he did not give the quote unquote truthful story was that he did not want to implicate this Menace person at the party where there were other people around who may know it, but he provided the same name of the individual at the initial incident. So to the extent that he told a lie initially because he was fearful of implicating someone who he was concerned about, he actually implicated the person at the original report date and just told a different story as to how it happened. In the bit of research and investigation I've been able to do from home, I've talked to two people who I believe will be able to confirm an alibi for Mr. Hardiman. He had a god brother by the name of Devontae Morris, whose birthday is January 1st. He will state that Mr. Hardiman arrived to his home at about 9 or so the day before, so the eve, that they didn't leave the area of the house until the next day. He lives in the area of Metropolitan Parkway, which is a distance from the prior street location where the incident occurred, and certainly from the Mapleton address where the car was recovered. I have a phone associated with Mr. Hardiman that I'm going to subpoena information for that I think will give us a clear answer as to whether or not my alibi holds any weight. But nevertheless, in light of the lack of actual violence offered in the allegation, his lack of adult criminal history, he was working on his GED at Atlanta Area Tech during the period of time that he came to be under arrest. There's no indication that this person has any reason to feel threatened by Mr. Hardiman. We would be asking for a signature bond through pretrial services, whatever the level is that has them reporting more frequently. I believe that's level 3.
Okay. So tell me a little bit more about Mr. Hardiman. He's 20. Is he an Atlanta native? What are his ties to the community besides he's known as Menace?
He is born and raised here in Georgia. He resides with his mother. He attended an alternative school but didn't graduate, which is why he was working on his GED at Atlanta Area Tech. He is working on trying to be an engineer, a music engineer.
And Mr. Hardiman, if released, would go back to mom's house?
That's my understanding. Mr. Hardiman, is that correct?
Mr. Hardiman, where would you live if you got a bond?
I would go back to my mom's house.
Okay, what's that address?
Actually, my mom has like relocated. I think it's like 3621 Ginnis Road.
How do you spell that?
Ginnis.
Ginnis Road, and where's that?
Southwest Atlanta, Georgia.
Okay. 3621 Ginnis, Ginnis Road.
Yes, sir.
Okay, and who lives with your mom?
It's just actually my mom. She has a boyfriend, but it's just like it's a small household.
Okay. Do you have any brothers or sisters who would live in that household?
No, sir. I'm the only child on my mother's side.
Okay. Do you have any kids?
Yes, sir. I just had a son.
Okay. How old's your son?
He actually just turned 2 months on May the 20th.
Well, you just did have a son. Okay,
Yes,
and
sir.
he's staying with his mom?
Yes, sir.
Okay. And where does she stay?
She stayed near Boulder Park Drive or something like that.
Boulder Park?
Yes, sir.
Okay. All right. So Ms. Hall, I'm at a little bit of a disadvantage because I can't get into Odyssey. I'm in Odyssey, but I can't open documents. They're saying something weird about the Adobe thing. So I've heard what Mr. Franklin said, that Mr. Dixon or Nixon said at first. Basically, it sounds like it's a stolen car case. And then it gets upgraded a little bit to I pat my side, and so the person has a reasonable apprehension that it's a carjacking. So tell me your perspective on the case.
Thank you, Your Honor. So to correct the victim's last name, it is Dixon, Dixon. Kyle is his first name. And Your Honor, my understanding of this case, after speaking with the victim and speaking with the officer who took the report, there were two different encounters of this robbery by the victim. One in which he told the officer when the officer arrived on scene, the report was being taken in the lobby of where this party was happening, and during which multiple people were walking past the officer and the victim while the story was being given. There was an investigator that was assigned to the case who had him come down to the precinct to take an interview with him. And during that interview, he asked him why, because at that point he knew who the person was, or he indicated that he was familiar with this person. He knew the person's name. He did later, during the incident, he did later go to the officer's car and tell him that his name was Menace, but that was all the information he gave on scene. So during the interview, the investigator asked him why didn't he give more details as that he's given that particular day, and he indicated that he didn't want to look like a snitch, for lack of better words. And it was so many people coming in and out of that party. The investigator pulled up the body cam to verify that, and he was able to verify that it was a lot of people coming in and out, and it was believable to him that that may have been why he resisted or hesitated in telling all the facts. But it's our understanding that he is familiar with this defendant. What actually happened was he was at this party and he heard the defendant mentioning robbing people. And when he left the party a little while after, the defendant was actually in his car, and he did put his hand to his side, holding his gun in his other hand. And he told him to get out the car, at which point the victim did get out of the car. Mr. Dixon got out of the car, and another individual got into the car with the defendant, and then they pulled off. The first encounter that Mr. Franklin was telling you about it was slightly different. He left the party. He noticed after he was inside of his car that he dropped his driver's license, which he told me really did happen. And then while he was picking up his driver's license just behind his car, two people got in the car and pulled off. So that was the first story versus I know who this person is. I've encountered him before. I know him to be this type of person. So when he was in his car, he told him, apparently, I'm not robbing anybody. I'm not going to participate in what I've heard you discuss inside of the party. And then that's when he took his car. Now, I have talked to the victim multiple times. The story hasn't changed for me other than the fact that he didn't want to give all this information out in the open. There was no injuries that day. There is no restitution. The car was recovered. There was no damages other than the damage that was already on the car when the car was stolen. But even light of all that information, Your Honor, even though there weren't any injuries, this was still a very serious crime. And the state is asking for you to keep the defendant in a no bond status. Although he doesn't have a juvenile record, he actually turned 20 this year. And so he doesn't have an adult record. He turned 20 this year, so I had his juvenile record pulled. And he has five prior cases in Fulton County. I didn't check the other counties, or our office didn't have the ability to check the other counties, but he does have those 5 cases from Fulton, 4 in which are closed and 1 that is still open. But in the 4 that are closed, these cases range from 14 to 16, 2014 to 2016, and they include robbery, battery, criminal damage to property, and having a weapon on school property or a school function. Those cases are now closed as the juvenile record, but there is still 1 open case that has possession of a firearm by a minor, possession of marijuana, carrying a concealed weapon are those current charges, but that case looks like it's still open. The fact that our victim and the defendant do have some kind of familiarity with each other, we do fear that he may intimidate our victim in this case if he's let out on bond, and we feel that he will reoffend, especially with all these recent cases when he was a juvenile. So our position is that he stay in a no bond status.
One thing to add as well.
I'm sorry.
Okay, let me ask Ms. Hall a couple questions first. So Mr. Dixon with a D, he knows Mr. Hardiman well enough that he would recognize him, it sounds like. And then what I wasn't able to follow, it does sound like the responding officer didn't pick the best location for the initial interview. But ultimately, was Mr. Dixon able to name Mr. Hardiman by name, or was it always, I know this guy and I know him as Menace, and the police had to take it from there?
So the latter, the victim knew him by his name. And once the police were able to pull 2 of his photos, I believe off of Instagram, they did complete a photo lineup and he picked out the defendant in the lineup.
Okay. But when you say by his name, again, Mr. Dixon would have been telling the police, you know, I don't know this, he may have described him, he looks this way and that. And I know him as Menace, not I know him as Hardiman or anything like that.
That is correct, Your Honor.
Okay. All right. And the way Mr. Dixon described it, they moved in circles that overlapped some. So it's not that Mr. Dixon is from Texas and happened to be in town for this event, but a concern he has and that you have is that their circles could continue to overlap if Mr. Hardiman is out on a signature bond.
That's true, Your Honor. That's true. Even in the account from Mr. Franklin, the party was on Pryor. He said he indicated where he was located was Metropolitan, which is technically the next street over. So, I mean, they do run the same, or okay, 7 minutes, about 7 minutes from each other, but they technically do run in the same circles. He didn't say they were best friends or any of that, but that he was familiar with him.
Okay. Mr. Franklin, you wanted to add some things.
2 large things, Judge. One, the juvenile record acknowledged is a juvenile record. And I say that to the extent that he's 20 now, and that would mean there's at least a period of about 2 years where we haven't had any concerns of Mr. Hardiman offending or continuing the behavior that was so troublesome and problematic during his youth. And addressing the actual robbery charge, I spoke to his mom about what that actually encompassed. It occurred in school when he was attending South Atlanta High School. He was with someone as the other person physically grabbed an iPad or an iPhone from another student, and they ran down the hallway. So it's something that in a lot of counties probably would have been dealt with a suspension from school and not in a criminal way. But, you know, things in APS have a tendency to end up in the court system as opposed to the educational system.
Okay. Does Mr. Hardiman have another place to stay, or his mom's place is the most logical, safest, etc.?
My understanding is that he's consistently stayed with his mom. I don't believe he has another place to reside. I did just text her and she confirmed with me the 3628 Jennings Road address. I believe she actually may be watching on YouTube as well.
Okay.
If anything else, Ms. Hardiman, just continue to text me about that.
Okay, so what address did she give you? That didn't sound exact, it was similar, but I want to make sure if I'm putting an address on a bond order, I'm putting the correct address.
She texted me 3628 Jennings, Ginnis Road.
Okay, that is just other than one digit. That's what Mr. Hardiman said. Okay, in Atlanta. Okay. Mr. Hardiman, does your mother work?
Yes, sir, but right now she's unemployed due to the coronavirus.
Okay. When she was working, what was she doing?
She's like housekeeping, like floor technician also.
Okay. And you were doing some school, were you working also? And Mr. Franklin may have said it, I didn't write it down. I know you were trying to get your GED at Atlanta Area Tech and you want to be a sound engineer or musical engineer, but were you working?
Yes, sir. I actually had a job at ABM Site Services, but they their contract had switched over, so that caused me to be laid off.
And what did you do at ABM Site Services?
I wiped tables and I pulled trash and I vacuumed.
And what kind of place were you doing that?
It was in It was like the Coca-Cola, the world of Coca-Cola near Georgia Tech
Okay. How long did you work there?
for like 6 to 8 months.
Okay.
His mom has added that it's apartment 3, Atlanta, Georgia, 30331.
Apartment 3. Okay. And Ms. Hall, did in either your conversation with Mr. Dixon or your review of the paperwork from Atlanta Police, did Mr. Dixon ever say that he saw a gun or that he felt that Mr. Hardiman had one because of gestures or a bulge in the pocket or what?
So he told the officers that he saw a gun in the party. He actually saw a gun. During the incident, he said that the defendant put his hand on the gun. So I didn't make him tell me, well, how'd you know it was gun? I didn't do that, but that's all he said to add to the gun.
And remind me, maybe I missed that there was some interaction between Mr. Dixon and Mr. Hardiman at the party that led up to the car situation?
Well, just that they were in a party together, and in the party, Mr. Dixon said that he could hear the defendant mentioning doing some robberies or robbing people. When he left the party, whenever after he decided to leave, the defendant got into his car with him, and I mean, I don't know what type of relationship that is, that it wasn't a conversation before, but he got in his car and he just told him, oh, I'm not doing any robberies, or that's not what I'm doing. And then he took his car is what I was told.
That he got in the car with him, not that he had a gun pointed at him or something saying, let me in the car. It was like maybe they're going to roll off together.
Right.
Okay, which is not inconsistent with what I heard from Mr. Franklin. Okay, I understand you guys are basing this off of sort of what you've read and heard secondhand. All right. Anything else, Mr. Franklin?
Nothing that I can think of, Your Honor.
Okay. Well, Mr. Hardiman, I am not going to set a signature bond. These are pretty serious charges. They may clear up over time, but these aren't the kinds of charges absent me hearing from the person who alleged you did it saying, I made it all up, it didn't happen, or something like that, where I think a signature bond would be appropriate. But I will set a bond. I think that there are some conditions that I could put in place that would most importantly ensure that you come back to court, but also that would put some space between you and Mr. Dixon. And I'll say this up front, if you're not able to make the bond and your case is stuck, it's not moving, and it's not because you and your lawyer are saying, let's go slowly, but if you're ready to keep your case moving and it's not, Mr. Franklin knows very well how to file another motion for bond. He does that for his clients because people are sitting there and it's not necessarily their fault that things are moving slowly right now. Sometimes it is because the defendant doesn't want to mess with the case, but if you're not able to make the bond, then soon enough, not tomorrow or the next day, Mr. Franklin can ask that we talk about bond again. What I'm going to do initially is set, I'll make sure I have the right number of counts here. I'm going to set a $40,000 bond. It's a good bond, so it can be made through a bonding company. It can be made through however you and loved ones on your behalf could set it. It'll be $20,000 for count 1 and $20,000 for count 2, and then 5. Whoops, I said 40. So it would be 15 for count 1 and 15 for count 2, and then 5 each for counts 3 and 4. And I assume there are only 4 counts. I can't get the indictment in front of me. I'm basing it off the calendar. So Ms. Nelson and I may have to adjust it, but the total will be a $40,000 good bond. The number one most important condition is that you have no contact with Mr. Dixon. That's no direct contact. Direct contact would be you picking up the phone or sending him a text where you are directly trying to communicate with Mr. Dixon. whether you're saying, I'm sorry, or why would you say this about me? No contact. If Mr. Dixon can show us that he is getting communication from you, not from your lawyer, but from you, that's the fastest way to go back to Rice Street if you make your bond. But no indirect contact either. It sounds like you may know some people that Mr. Dixon knows. It is not okay for you to use an intermediary, some go-between, to say to a guy, hey, tell Dixon whatever, whether it's something nice, not nice. If people on your behalf are trying to communicate with Mr. Dixon, it's going to be your problem and not the person who is serving as the go-between. Does that make sense?
Yes, sir.
Okay. And in this day and age, it's real easy to basically put up a sign, but it would be an electronic sign that says, I'm watching you, Dixon. So you would need to be smart about Instagram or Facebook or wherever you might be active online. If Mr. Dixon is able to show the prosecutor, and ultimately it will come to me, that you've been posting things that would be available to anyone to see, including Mr. Dixon, that could reasonably be understood to be you trying to say something to Mr. Dixon, again, that's going to be your problem and not Instagram's problem or anyone else's. So you just need to leave him alone. If you are walking down the street and you see him coming in the other direction, you turn around and walk away. So he doesn't have any sense that you're trying to get up in his business. So that's number one. Condition number two will be that you reside at your mother's house at 3628 Guinness Road, apartment 3 in Atlanta. And you will be on a curfew initially. If you can document that you're going to school, if you can document that you have a job, then you can be leaving your mom's place for work or for school. But otherwise, you need to be at your mom's place and not somewhere else. If you want to see your little boy, and I bet you do, your little boy needs to come over to your mom's place and not you going over to your son's mother's place. We might adjust that over time, but initially you will be staying 24/7 at mom's place. It's a whole lot better than where you are now. But again, if you get employment or you're going back to school, you can document those hours. We can turn it into a curfew rather than house arrest. You'll be subject to pretrial supervision. I'm going to have to modify your bond a little bit to make that happen. And you'll be level 3 supervision, which means you're checking in, I think, at least weekly. And that may be on the phone rather than you show up in person, but you will be on pretty close pretrial supervision. I don't think that people can be on pretrial supervision if their bond is through a bonding company. So, Mr. Franklin, do I need to split it where one of the counts is through the sheriff's 10% program, or how do we not create that situation where he can't do it?
To have him be able to have the flexibility of going through a bonding company and be on pretrial, just one of the counts. So maybe like the last count, the possession during or something.
Okay.
Make that count a straight signature bond. And since he won't actually be able to get out on that because he's held on the others, just make sure the other 3 total whatever the 40,000.
So I have an even better approach. I didn't realize that Ms. James was with pretrial, but she kind of winced while you were talking. And so let's hear directly from the subject matter expert. Ms. James, if I want Mr. Hardiman to be on level 3 supervision, but more importantly, subject to pretrial supervision, but I was thinking originally good bond so he can get through a bonding company. How do we need to structure this? What I typically do is just say sheriff's 10% program, but I have learned that sometimes makes the bond more expensive. But I know you all will participate in supervision if the bond is through the sheriff's 10% program.
Yeah, that's correct. You can do the 10% program, Your Honor.
But if I don't want to do the 10% program on all the counts, how is there a way to have some of the counts on bond, like through a bonding company, and then some of the counts through pretrial supervision, or can you not mix and match like that?
Yeah, you can split it, but from my understanding, I know certain charges, if I'm not mistaken, and if anybody can help me out, certain charges we're able to take, certain charges we aren't. That's why some charges are split. Like you might have a firearm be split and go through the jail because we can't take firearm versus to have marijuana possession or simple battery or things like that go through pretrial. But I know you definitely can split.
Okay, but if the 4 charges are armed robbery, carjacking, aggravated assault, and possession of a firearm, are those all 4 ones that you wouldn't supervise anyway, given the nature of the crime?
That's correct.
So I definitely don't want to pretend like I know more about Miss James Lane than she does, because that's her thing. But I know that I've definitely had clients receive signature bonds for armed robberies before. So I think maybe Miss James, what she may be referring to is that when they do the pretrial assessment based on certain charges, you'll never hear pretrial recommend
Right.
a pretrial bond for such and such.
Right, and that's
Or
correct.
armed robbery. But
And
when
we can pretty much take any charges. Certain, you would just have to split it however you would like to split it. If you want the armed robbery to go or the hijacking to go, it just depends on your discretion, Judge.
Okay. All right. So let me, I'm sorry to recast it, but I guess what we'll do is counts 1 and 2, the armed robbery and the carjacking, are still 15,000 each, and those are good bond. Count 3 will become 10,000, also good bond. So it's a $40,000 good bond. Count 4 is a signature bond, and that's subject to pretrial supervision level 3. And then all those conditions I talked about, you live with your mom, no contact with Mr. Dixon. Any other conditions, Ms. Hall, you'd want to have on the bond?
Nothing from the state, Your Honor.
Is there a stay away? I don't want us giving up Mr. Dixon's address. It's stay away from Mr. Dixon. And it doesn't sound like where the party was Mr. Dixon's address. There's not really other than stay away from an individual, there's not a location that Mr. Hardiman would stay away from.
That's correct.
Okay, all right. I think that's where we are. Anything else, Mr. Franklin?
Nothing from me, Your Honor.
Mr. Hardiman, do you have any questions about any of that?
No, sir, Your Honor.
Okay. Well, Ms. Nelson and I will get that paperwork together and we'll see what happens. Thank you, Ms. James.
You're welcome, Your Honor.
All right, Mr. Hardiman, I'm going to talk to your mom and see what she can do to make it, okay? I'll be in touch when I can.
All right, thank you, sir.
You're welcome. That concludes my business, Your Honor. May I be excused?
Yes, sir.
All right, thank you. You all have a good day.
You too.
Thank you, Ms. James.
All right, let's turn back to Mr. Parrott. I appreciate your patience, Mr. Parrott, and Mr. Hudson. Mr. Hudson's even changed clothes. It's taken so long.
Yeah. Yes.
Mr. Forte, you ready to pivot back to Mr. Parrott? Okay, we're back on the record in Mr. Parrott's case. Mr. Hudson, did you and Mr. Parrott have enough time to speak in confidence in the breakout room?
Yes, Your Honor, and we've agreed to take the plea recommendation by the court.
Okay, Mr. Parrott, I'll remind you, as I told you when we last tried this, when you were here in court, I'm not binding myself to what I said. I may hear something in the conversation that we're about to have about your case that prompts me to say, what? That's crazy. You got to serve 5 years. You will have the ability to withdraw your plea. You haven't lost that ability right now. I was giving you a forecast based on what we had talked about in court on the record with you there when your plea did not go through last time, and then the additional information that Mr. Hudson and Ms. Hall had shared with me. So just like I'm not bound by what I told you, you're not bound by the plea unless and until you hear what sentence I'm going to impose. I suspect it'll be along the lines of what we talked about. And then you will have a chance to say, no, thank you, if it is other than what we've talked about. Does that make sense?
Yes, Your Honor.
Okay, let me cover two things before Ms. Hall puts you under oath. Number one, you have a right to be here in court, sitting at the table where you sat before with all the other folks involved with this case around you. But you are appearing remotely right now. You are on a screen. You can hear what I'm saying and your lawyer and Ms. Hall, but you're not in the same room with us. Do you waive your right to be here in court?
Yes, Your Honor.
Okay. The second thing, and it's related, you have a related right of having Mr. Hudson to be by your side, so that if you have a question about what's going on or a concern, you're able to lean over and say, hey, what about this or that? And he can whisper in your ear, and you know that you've got that good lawyer right by your side. That's not the case right now. You are on 5 North, and Mr. Hudson is wherever he is right now, someplace with a white
I'm in
seat.
my office.
His home. He's in his home. He's in his palace. So you guys aren't right next to each other. You don't have to work this way. You could say, I'm going to wait till we can be sitting next to each other. I don't know when that's going to be. Or you can waive your right to have Mr. Hudson right there by your side, and we can go forward with the plea today. Are you willing to waive your right to have Mr. Hudson by your side?
Yes, sir.
Okay. The one thing I can help with, I can't get everyone in the same room, but if at any time during this plea conversation that we're going to have, if you need to have a private one-on-one with Mr. Hudson, I can move you guys into that breakout room again. Will you let me know if you need that?
Yes, Your Honor.
Okay. And same for you, Mr. Hudson. If you think you need time with Mr. Parrott, we'll get you back in the breakout room. Okay.
Thank you, Your Honor.
All right. With those waivers, we will start the plea conversation. Ms. Hall, if you would put Mr. Parrott under oath, and then it's all yours.
Thank you. Your Honor, I just want to clarify one thing. So are we now, is this still negotiated, or are we turning it to non-negotiated? It doesn't matter for me. I'm just asking for clarity.
I'm with negotiated.
So it's negotiated in the sense, as I understand it, you and Mr. Hudson have agreed down to the decimal point how you two think it ought to be resolved. So it's very much negotiated in that respect. There was a question about whether that negotiation had addressed the concerns that I raised when we were together in court. And I answered that at the outset on the record that not quite. And I think I'm at location X. And I wanted to give Mr. Parrott and Mr. Hudson a chance to talk about it. They have. And so what I've heard Mr. Parrott say is, I really like what was negotiated, but Judge, if you end up going along the lines of what you, Judge, described, I'm still good with it. So it is negotiated, but in the same way that if I undercut, you could withdraw on behalf of the state. Mr. Hudson is in a position on behalf of his client, if I were to do something beyond what I shared with you all at the start of this conversation, Mr. Parrott could say, no thanks, we'll try again later.
Understood, Your Honor. Thank you.
Yep.
Ms. Parrott, can you please raise your right hand? Do you swear or affirm the testimony you should give in the matter currently before this court should be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
You may lower your hand. Please state your true, correct, and legal name.
John Travius Rashawn Parrott.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there any medication that you normally take that you have not been given today?
No, ma'am.
How old are you and how far have you gone to school?
I'm 23 years old. Made it to the 10th grade.
And are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you've been charged with 4 counts of aggravated assault, 4 counts of criminal damage in the first degree, and 4 counts of possession of a firearm during the commission of a felony?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to those charges? And if you plead not guilty or remain silent, you may receive a jury trial?
Yes, ma'am.
Have you had enough time to speak with your lawyer, Mr. Hudson, about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, ma'am.
Do you need more time to discuss this case with your attorney?
No, ma'am.
Are you satisfied with his services?
Yes, ma'am.
Mr. Parrott, could you get a little closer to the screen? Because I'm having trouble hearing you, which means probably Mr. Forte is as well. And you can just sort of belt it out. Yes, no, whatever you're answering, okay?
Yes, sir.
Perfect. Thank you. Much better.
Counsel, do you waive formal reading of the indictment?
So wave.
Do you waive any and all defects in the indictment, including with respect to the defendant's name?
So wave.
Mr. Parrott, have you been arrested on these charges?
Yes, ma'am.
The state is unaware of any outstanding warrants that are related to these charges. Do you or your attorney know of any outstanding warrants related to these charges?
There are no warrants.
Mr. Parrott, have your attorney advised you of the minimum and maximum sentence to each charge that you're pleading to?
Yes, ma'am.
The minimum and maximum for aggravated assault is 1 to 20 years to serve. The minimum and maximum for criminal damage in the first degree is 1 to 10 years to serve. And the minimum maximum for possession of a firearm during the commission of a felony is 5 years to serve, to run consecutive to any other charge.
Yes,
You understand?
ma'am.
Do you understand that do you understand that this is a negotiated plea of guilty, which means the state will recommend to the court a sentence for the 4 counts of aggravated assault and the 4 counts of criminal damage to property in the first degree. The state recommends 5 years to serve 4 months credit for time served. And as far as the 4 counts for possession of a firearm during the commission of a felony, the state's recommendation for count 9 would be 5 years suspended to run consecutive to count 1, but the remaining 3 would be suspended runs concurrent to count 9. Did I make that clear, Your Honor?
Why don't you try one? So what do you think the total sentence is?
The total sentence would be 10 to serve. Well, we have that 5 year suspended. So I think it'll be a total of 10 served, 4 months credit for time served.
Okay. And then it would be 4 years and 8 months probation, followed by 5 years suspended.
Yes, Your Honor.
Okay.
Do you, Mr. Parrott, do you understand that the court does not have to accept that recommendation? The court can sentence you to the maximum on each of those charges and can run those sentences consecutively or one after another.
Yes.
And I also want to add for the record, there is restitution due in this case to Mr. Ronald White, Reginald, White as in the color. That restitution amount is $643. And also restitution to Tara, T-A-R-A, last name Laney, L-A-N-E-Y. And that restitution amount is $500. Mr. Parrott, do you understand this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as other jurisdictions, including the federal courts?
Yes.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea today?
Yes, ma'am.
Do you understand if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that you're not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Do you understand if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just as a conviction at trial would? And this is true regardless of any advice by your attorney or anyone else.
Yes, ma'am.
Do you understand there may be other adverse or unfavorable consequences to you following a conviction from trial? For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes, ma'am.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
Yeah, ma'am.
Are you asking to be treated as a first offender under the provisions of the First Offender Act?
Yes, ma'am.
Have you ever pleaded guilty or nolo contendere to, or ever been convicted of a felony in the state of Georgia or any other jurisdiction?
No, ma'am.
Have you ever been sentenced for any crime, felony, or misdemeanor under the First Offender Act?
No, ma'am.
Has your lawyer explained the First Offender Act to you?
Yes, ma'am.
Do you understand that if you violate the terms of the first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked, you could be adjudicated guilty, and you could be resentenced up to the maximum sentence for each charge in this indictment?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand that if you went to trial, you would have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to remain silent and not incriminate yourself?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes,
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea today?
no, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Yes, ma'am.
How do you plead to the charges of 4 counts of aggravated assault, 4 counts of criminal damage to possession of firearm during the commission of a felony in indictment number 20-SC-174043?
Yes.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that you only have 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Thank you. Your Honor, I know I've went over these facts before, but to give them to you again on the record, on December, if the state had moved forward to trial, the state would have proven that on December the 10th, 2019, at 1197 Joseph E. Boone Boulevard, Northwest, Atlanta, Georgia, in Fulton County, officers were dispatched to that location in reference to a dispute. Upon arrival, they spoke with witnesses that encountered a shooting that took place in that apartment complex. The defendant, Mr. Parrott, was identified as one of the shooters, as well as co-defendant, or I'm sorry, cross-defendant, Mr. David White, whose case is being handled in another courtroom. But for the record, the SC number is 20-SC-174048. In this incident, the reports were given to officers that the defendant had thrown, a witness watched the defendant throw a grill top at a window at the apartment complex. And after that, a gunfire started between both Mr. White and Mr. Parrott. In the exchange of gunfire, Mr. Parrott shot into an apartment complex. The co-defendant or cross-defendant, Mr. White. His last name is Williams. I'm sorry. Mr. Williams fired from out of the apartment complex. And when the police arrived, there were witnesses that had damages to their vehicle, being Reginald White being one of those victims. and Tara Laney being another one of those victims. There was also gunfire that happened to a window of one of the apartment complexes, but the apartment complex did repair that window, so there's no restitution being requested for that damage. But there was a little information given as to how this happened. I do know that the report was given, that Mr. Parrott felt like the person, Mr. Williams, that was inside the apartment complex was intentionally messing with him, according to the report, and that he did reach out to his mom to try to get some help there. The owner of that house was the defendant's sister, and that was someone that she had living with her at the time who was shooting at the defendant. No one was hurt in this incident. There was just damages to those vehicles and that window to that apartment complex. And I believe that's all of the facts for this case, Your Honor. The defendant does not have any prior felony convictions. Yes, he don't have any prior felony convictions. That's all from the state, Your Honor.
Okay. Ms. Crawford, do you agree, Mr. Parrott, no adult criminal history in Georgia?
That's correct, Judge. He has no record found in Georgia.
Thank you. So when we were last working through this, the restitution amounts were a little different. It was a little less for Ms. Laney and a little more for Mr. White. Any reason why that would have changed, Ms. Hall?
So when we were in court, I think it was back in February, I didn't have exact numbers. I was given guesstimates. And when I spoke with Mr. White, his number did go down. He hasn't gotten his vehicle repaired, but he got a better estimate, is what he told me. So that went down. As far as Ms. Laney, there was actually more damage done to her vehicle than what she had gotten done at first. I honestly haven't gotten that final number from her. I'm just hoping that it's not more than 500. We have contacted, me and Ms. Rolak has contacted her a couple times since we're working remotely from home, but I haven't gotten a response. The first amount that I gave you was only for one of her damages, which was the window, but
Okay.
she also had damage to her trunk, and it made it where it wouldn't close. So that amount may actually be a little less than the actual amount, but I'm safe to go with that because I would rather her get her car repaired than nothing at all.
Yep. Okay. And you, it sounds like, or Ms. Rolak, have been in pretty regular contact with the victims here who are property victims. Fortunately, they were not in their cars when Mr. Parrott shot them up. Are folks okay with this disposition?
Yes, Your Honor. Back when we were in the office, when we attempted to plead the first time, I actually personally talked to all of the victims, including Mrs. Laney's husband was involved in one of the conversations. And I received more details as to their position, but all of the victims pretty much said the same thing to me, that they didn't want too harsh of a punishment to the defendants. I did explain to them, I was very candid with them to let them know the information that they was not aware of that could have been going on with the relations and the people being in the house and all that. And they were okay with the probation that we came up with. And that was one of the reasons why I did go down to probation and not time, because Miss Laney was in her car right before the shooting. And her husband, for some reason, just told her to get out and come in the house, and then it happened. So it was serious, but after talking to even her who could have been shot, they were okay. They believe in rehabilitation. So that's where they stood on that.
And the relationships were, Mr. Parrott's sister lived in the apartment, and David Williams was, maybe still is, but was her boyfriend at the time. And Mr. Williams and Mr. Parrott were the one, or what am I missing?
Okay, so, and Mr. Hudson, correct me if I'm wrong, it's the sister's house and this is her brother, but apparently the sister allowed the brother, Mr. Parrott's ex-girlfriend and the new boyfriend to live with her.
That's
and
correct.
So that became an issue when the brother would come and visit his sister, and there's the ex and the new boyfriend living with his sister.
So Mr. Williams is the new boyfriend of Mr. Parrott's ex-girlfriend who are both living with Mr. Parrott's sister.
Right. There's some type of friendship between the ex-girlfriend and the sister. So she allowed them to live with her, and then it became a problem, you know, understandably so. So if the, you know.
Okay.
And I actually talked to, I'm sorry.
Go ahead.
I was just gonna say, I actually talked to one of the sisters, and with Mr. Hudson, you know, if you remember, he was holding us up and tracking us down for this plea. So in that time, I was able to talk to some of the family members in court back in February who confirmed all the relations.
Okay.
And my victims actually were the first people who told me who was living and what the situation was. So they knew what was going on, and they actually felt bad for Mr. Perry, if I can be completely candid, because they said that people were messing with him and he was trying. And I believe I told you all that when we attempted the plea at first.
Yep.
But so everyone's familiar with it, but apparently it was a disagreement that particular day.
Okay. So Mr. Parrott lives where, Mr. Hudson? Or where will he stay when he does get out?
Your Honor, can he give you that address? But he's not at that location. He's gonna stay with his grandmother. I believe she lives on Simpson Road or Boone Boulevard.
Okay, and actually, you can live where you want, Mr. Parrott. I'm just thinking it's probably a good idea for you to stay away from the location where the shooting happened. In other words, if you're gonna spend time with your sister, whose apartment you ended up shooting up, she needs to come see you and not the other way around. Do you have any reason other than your sister why you would need to be around that apartment complex? I didn't hear your answer. Oh, I may have muted you. Let me unmute, sorry.
Oh, no, Your Honor.
Okay, what's the name of the apartment complex?
I really don't know, Your Honor.
Okay. What's the address of the apartment complex? That ought to be in someone's paperwork where the shooting happened.
It is 119.
Oh, you mentioned Joseph E. Boone, but I interrupted you. So it's what?
1197 Joseph E. Boone Boulevard, Northwest. And this happened at apartment 31.
Okay, well, you can stay away from all the apartments there. Okay. So that apartment complex at 1197 Joseph E. Boone, Mr. Parrott, you don't have any reason to go there other than to visit your sister?
No, Your Honor.
Okay. Ms. Rolak, I noticed you became visible while we were talking about the case. Is there anything that you wanted to add on behalf of any of the victims in this matter?
Not at this time, Judge.
Okay, thank you for dialing in. Okay. Mr. Hudson, what do you want to share with us?
Your Honor, Mr. Parrott is still, he's still going to try to get his job back at FedEx. He was there for 4 years, Judge, prior to this incident. So that's all I wanted to add, Your Honor, and that this is his first arrest. And Your Honor, he's in agreement with the sentence that the court is willing to impose. And I ask that, Your Honor, you give him first offender and credit for the time since he's been in custody.
Okay. Mr. Parrott, anything you want to add?
No, Your Honor.
Your son, Don Travis Jr., he stays with his mom or your mom? Where's he staying?
He stayed with my mother.
With your mother?
Yes, Your Honor.
Okay, and is that where you would go live when you get out?
Yes, Your Honor.
Okay, and where does your son's mother stay?
Hightower.
Hightower?
Yes, Your Honor.
Okay.
Your Honor, that's off Hampton E. Holmes Drive in Northwest Atlanta.
Yeah, okay. All right, well, Mr. Parrott, I find there's a factual basis for your plea. Sounds like you and Mr. Williams got into it, and that maybe there had been a history of some friction there. I told you before, but I'll say it again. You didn't handle it the right way. You just got to walk away from something like that. Throwing the barbecue grill was trouble enough and probably could have gotten you arrested. But the moment you pull out a gun, it's going to go downhill from there. You are blessed. You may not feel like it, having been at Rice Street for a while, but you are blessed that no one got hurt. All that happened, I say all, it's still scary. Some cars got shot up, but it could have been so different. And we wouldn't have been talking about probation. We would have been talking about how many decades will you spend with the Department of Corrections. And Dontravius Jr. never really knows his dad. So that's something that you need to not do again. Doesn't matter how much someone tries you, you need to get yourself out of that situation. You can share a few choice words with whoever it is as you're leaving, but you just got to get out of there because that you got involved with something real dangerous. I find that your plea is knowing and voluntary. Knowing means you've understood all the things we talked about. Is that true? Is that fair?
Yes.
Do you have any questions about anything? Okay. Voluntary means no one's forcing you to enter this plea, but that you have decided with the advice of your lawyer that going forward with the plea is a good idea for you. Do you agree with that?
Yes.
Okay, then I'm going to accept your plea. I'm sentencing you pursuant to the Probation Options Management Act. And all that means is that while you are on probation, if you have a small or technical problem, like you miss a meeting with a probation officer, or maybe you have one positive drug test or something like that, you don't have to come see me, but you'll work through probation on something like that. If it's more serious, new charges, you got arrested, then you'll come back and see me. I will sentence you as follows, Mr. Parrott. On counts 1 through 8, I'm sentencing you to 5 years to serve 6 months with the balance probated. And those 8 counts will all run concurrently with each other. That means at the same time. And you will get credit for all the time you've been in. The remaining counts have to run consecutive to the other counts. So I'll run them consecutive to count 1, and they'll all be 5 years. I'll run them concurrently with each other. And I will suspend that. So your total sentence is actually 10 years to serve 6 months. Then you'd be on probation for 4.5 years. And then those last 5 years are suspended, meaning you're not under supervision. You don't have to pay any supervision fees, but they're important. And here's why they're important. You want to be treated as a first offender. And I'll tell you, that is a tough call for me. You certainly qualify for it. You haven't been in trouble before as an adult, but you've certainly gotten in trouble in a pretty whiz-bang way. And I'm a little reluctant because the way you got in trouble is you fired a gun, but you've had a job for a while. That's promising. Sounds like you got a nice young man as a son. That's promising. And a felony can make it real difficult for you to try to do the right thing for yourself and your family. So I will sentence you as a first offender, but you need to tell me that you understand the risks and the benefit of first offender. The benefit's pretty clear. It means this is not a conviction. If you're trying to get a job, you don't have to check that box that says I'm a felon or that you're convicted of anything, because you're not. You are a first offender. Do you understand the benefit of first offender?
Yes.
Here's the risk. For the remaining 9.5 years, that part that's suspended, that's 5 years, and the 4.5 years of probation, if you mess up in a real serious way, and I'll tell you what would be serious, if you're caught with a gun, you got a gun in your pants, you got a gun in your backpack, you have a gun in your hand, you're caught with a gun, that's a crime, because first offenders, while they are under sentence, cannot have a gun. So there would be new charges. You come back in front of me, and not only can I revoke your probation, that's the easy part, I actually can take away your first offender status. And because you've pled guilty, Without a trial, all I'd have to do is be convinced that you violated your probation, and having a gun would do that. I could resentence you up to the maximum in your case, which is more than 100 years. I probably wouldn't do that. I mean, if you went and shot someone and they died, not only would you have murder charges, but I'd revoke as much as I could in this case. But you need to understand that without another trial, and certainly Mr. Hudson could represent you in the hearing that we'd have on the revocation of your first offender status, but without a trial, and the state's burden of proof would be a lot less than it would if they were trying to convict you at trial, I could take away your first offender status and resentence you. And I have a lot of room to work with all these aggravated assault charges. And I tell you that not because I hope to see you again. I don't want that to happen to you, but I need to make sure you understand the risk. You are young and life is going to be challenging. And if you are running around getting yourself in a situation where you think the right thing to do is to have a gun and pull that gun out, it could bite you real hard on the backside if you get in trouble because you could have that first offender status taken away and a new sentence imposed. Do you understand that risk?
Yes, Your Honor.
Do you think it's smart for you to take that risk?
Yes, Your Honor.
And why do you think that?
To be honest, I stay out the way. I be working half of the time, so I wouldn't have a chance to have that in my hand.
Good. That's a smart answer. If you're busy and not running around with goofballs like this David Williams guy, then things may be okay. I just need to make sure you appreciate the downside. First offender is a great thing, and I am taking the risk of giving you that chance. I just hope that I didn't make a poor decision because I see you in 6 months or a year and you've done something you shouldn't have done, because that'll come down pretty hard on you. All right, I will sentence you as a first offender. And here are the conditions of your probation. Number one, you are going to pay $643 in restitution to Reginald White. You actually don't hand him any money. You'll pay the money through probation, and you don't have to pay it all at once. They're not going to show up and say, give us 600 bucks. You'll pay it as you are able. You will also pay $500 restitution to Tara Laney. That's L-A-N-E-Y. I am sentencing you under POM, as I mentioned, the Probation Options Management Act. I'm going to waive your probation supervision fees for the first 5 months, partly because it's going to take a little bit for you to get back to work, but also because I want you, as you're earning money after you've taken care of your little boy and whatnot, that money should go to restitution and not to probation supervision. I'm going to require you while you are on probation to get your GED. You don't have to do that in the first month or the third month, but you need to be working towards getting your GED. That'll help you out on the work front. And then no contact at all, direct or indirect, with David Williams. And you will stay away from the apartment complex at 1197 Joseph E. Boone Boulevard, Northwest, here in Atlanta. Again, if your sister lives there, she's going to have to come visit you if you two are going to spend time together, but you need to stay away from that apartment complex. Ms. Hall, anything else for Mr. Parrott's case?
Nothing from the state, Your Honor.
Mr. Hudson?
No, nothing, Your Honor. I just want to say thank you for the recommendation and for helping us resolve this case.
Well, you're welcome. Mr. Parrott, I know that's not exactly what your lawyer had negotiated. It's a little more severe. You'll be staying in custody for a little bit longer, but again, you'll get credit for all the time you've been in. Do you want to go forward with this plea?
Yes, Your Honor.
Okay, well, that'll be your sentence. Ms. Nelson, do you have any questions while we've got all the folks on the line about the sentence?
No, I do not. I think I have everything. Let me look at it right quick. Oh, the 5 years on the counts.
Oh, right. So I thought I maybe didn't say that. Counts 9 through 12 are 5 years. I think I talked about this. They run concurrently with each other, but consecutive to count one.
Got it. Okay. I just wanted to make sure that you're suspending the consecutive to count one suspended, correct?
Yes, ma'am.
Okay.
All right. That does it. So Ms. Nelson will fill out that paperwork. I'll sign it, and that'll get things rolling. Good luck, Mr. Parrott. Hope you stay busy in good ways as you go forward.
Thank you, Your Honor.
All right. I think that's it. Thank you, 5 North.
You're welcome, Judge.
Thank you.
Thank you, Ms. Hall.
You're welcome.
See you next time, Judge. We got other business coming up.
Good. Make it happen.
All right, see you.
All right. Thanks, Ms. Crawford, Ms. James,
You're welcome, Judge. Thank you.
and Mr. Forte. Thank you. It was all good. We'll be in touch soon.
All right, have a good, bye.